Hi, my name is Danie Mellas, Senior Associate at Nichols Family Lawyers with offices in both Melbourne and Geelong. Today, we're going to explore an issue which often arises in family law proceedings: loans. Is it a loan? Is it a gift? What is it? When determining a property split, one of the key factors when attempting to resolve a property matter is working out what is part of the property pool. Things can get a little bit more complex when one party raises that there is a loan between family members or loans from third parties. So let's break it down. A common dispute in family law cases is whether money given to one or both parties was intended as a loan or as a gift. The distinction is crucial. A gift is a voluntary transfer of money or property given without the expectation of a repayment. This might be a lump sum payment or even a property from, for example, mum and dad. A loan, on the other hand, is money that is expected to be repaid, often on agreed terms, and at times also comes with interest repayments. Under Section 79 of the Family Law Act, the court must take into account any liabilities incurred by either party when determining the property pool. This, of course, naturally includes any associated loans. But what happens when it's unclear as to whether or not the money was a gift or a loan? This is where the presumption of advancement comes in. Simply put, if a parent gives money to a child, the law presumes that it was intended as a gift. However, this presumption can be overturned if the evidence shows that the money was to be repaid by way of a loan. This can be categorized as a legitimate loan. If the court finds that the money is a gift, it is then treated as a contribution by the receiving party to the overall property pool. It becomes part of what is divided between the parties rather than being treated as a debt to be repaid. On the other hand, if a court finds that there was a loan, it would be treated as a liability of the parties, reducing the property pool available for division. This means that it must be repaid before the remaining assets are divided between the parties. So, how does the court decide? Evidence is key. The strongest evidence is a written signed loan agreement setting out the terms of the repayment. But even without one, there may be still proof of a loan. For example, records of bank account statements, written acknowledgements that the money is expected to be repaid. So, what is the best way to protect yourself and any financial contributions you received? Generally, the two most effective options are entering into a binding financial agreement together with an accompanying loan agreement. The loan agreement will set out the essential details of the arrangement, including the lender and borrower information, details about the loan itself, a repayment plan, and what happens when the repayments can't be made. Having both parties sign the loan agreement is considered best practice, as it prevents one party from later denying the existence of the loan, particularly if the marriage or relationship ends. A financial agreement, on the other hand, is a legally enforceable document between a married or de facto couple, and it can be entered into before, during, or after a marriage or de facto relationship. Where one party's family has provided or intends to continue providing significant financial assistance, a binding financial agreement can clearly outline how property and liabilities will be divided in the event of a separation. This can also document whether there are any gifts or loans for either party. It is strongly recommended that the parties seek their own respective independent legal advice before entering into any loan agreement or financial agreement. At Nichols Family Lawyers, we have extensive expertise in advising and representing clients in property matters. And if you would like tailored advice about your situation, please contact our office to arrange an initial consultation.